Thanks, everybody. Great to see you in our closing session. And for our closing keynote, we have Bruno Gencarelli from the European Commission. Bruno, welcome back to Spokes. Thanks so much for joining us today.
Thanks for having me. Hi, Justin.
Well, Bruno, I know we have a short discussion today, and it's part of our closing discussion, but a lot to talk about since we last saw you, and a lot of areas of interest. So let me start with the first, which is we get you in Washington, D.C. for the first time in a long time. The Commerce Department mentioned earlier today publicly that the European Commission is here on some follow-up discussions to the summits in Europe involving President Biden and other world leaders in the last few weeks. So obviously, some really exciting developments from the privacy community, I hope. And I'm hoping that, that there's a focus here, for example, on a renewed privacy shield. So let me start with this. Bruno, obviously there's been a lot of focus on the privacy shield for a lot of reasons. And among other things, the Schrems II underlying decision affected in many ways, not only transfers under privacy shield, but there were strong implications for standard contractual clause transfers, binding corporate rule transfers, and transfers under any derogation at the moment. So getting another adequacy decision for transfers to the United States is incredibly important for a lot of companies, certainly for small and medium-sized companies. Maybe I just start, Bruno, could you give us a little bit of a sense of the timing and engagement that there's been on a what I'll call revised privacy shield for now until we know if there's a new name?
Yeah, well, when the discussion will be about the name, I think that would be a very good indication that we have solved everything else. Well, developing a successor arrangement to the privacy shield following the Schrems II judgment is clearly a priority on both sides of the Atlantic. And there has been indeed an important visit of President Biden to Brussels 2 weeks ago on the 15th of June. And as part of the visit, there has been, I think, a very good meeting between Secretary Raimondo and Commissioner Renders, the European Commissioner for Justice, who is responsible for these files. And indeed, as a follow-up to that meeting, we are meeting for the first time in person with our US counterparts to explore a number of solutions that should, we hope, bring us closer to an agreement. So, as you can see, this is a top priority for us. I know it's a top priority for the US administration. There is a lot of eagerness, willingness on both sides. There is also an understanding of the complexity of the issues we have to deal with, which are, as you know, about the interplay between privacy on the one hand and national security on the other. That's always a complex question. It's an essential question. It's an important question, and it's a complex one. And we are, and I think our US interlocutors also share that view. What we want to develop is an arrangement which is, of course, sustainable, which will deliver the legal certainty that stakeholders not only expect and deserve. And the only way to do that is to have an arrangement which is fully in line with the judgment set by the Court of Justice in the Schrems II judgment. The requirements set by the Court of Justice in the Schrems II judgment, which, as you know, relate to proportionality, necessity, the nature of the interference and the limits of interference with privacy in the area of national security, as well as the redress mechanism that should be available to individuals. So that's what we are discussing. I cannot tell you when we will reach an agreement. But I can confirm you that at all levels, this is seen as a priority.
Well, so Bruno, if I may, the Schrems II decision was really focused, as you mentioned, on necessity and proportionality of, for example, redress with respect to intelligence collection. I understand that you may not be able to commit that the next framework is going to be called Privacy Shield, but just for purposes of us talking about it, since we don't know the name, maybe we'll call it Privacy Shield 2 for a moment. Are you okay with that? Just for the
yeah, well, an adequacy decision. I think that what we are aiming at is a new adequacy decision, because we see the enormous benefits of an adequacy decision, both for the protection of the data which is transferred, and in terms of legal certainty. An adequacy decision is something that companies can rely on without having to think about the type of case-by-case assessment which is otherwise required by the Schrems II decision. So, I mean, the names, whether you call it Paul, Nicole, or Privacy Shield, I don't think that is very important. Call it Justin or Bruno, but what is important is the nature of the instrument. What we are aiming at here is a new adequacy finding.
Right. So the adequacy finding with respect to, say, Privacy Shield 2, right now, we know that if you're a company that previously certified under Privacy Shield, you can't transfer data under Privacy Shield because it's not an adequate means of transfer currently. But there are a lot of companies that are still maintaining their commitment to those public declarations under the old Privacy Shield. So can those companies assume that the focus here is on the national security redress and accountability issues, and that the commercial items that are in the old Privacy Shield should stay the same as far as the expectations are? In other words, the real negotiations are on the country-to-country national security redress and accountability items that we talked about.
So the short answer to that question is essentially yes, in the sense that talking from a European point of view, from a GDPR point of view, the Privacy Shield is in its current form is that it can no longer be, as you said, it cannot be no longer be relied on to transfer data from the EU to the US. The Privacy Shield was annulled, was squashed, for reasons that concern indeed access by a public authority, in particular national security authorities, to data, which is in the first place transferred for commercial reasons. The Schrems II judgment is a mandate in this negotiation. Therefore, you indeed you will understand that the discussions are around those issues, which once again about on the one hand redress, and also on the other hand the limitations condition under which data can be accessed for national security reasons, so necessity, proportionality, or equivalent concepts.
So, and the good thing might be, Bruno, out of that is, assuming you reach a new adequacy decision, if companies maintain what they were doing under the old Privacy Shield, their conduct shouldn't have to change. It's really arrangements country to country that would be affected by the agreement as is currently contemplated. Is that right?
Of course, I cannot pronounce myself on the outcome of a negotiation before that negotiation is concluded, but I can confirm that indeed the focus of the negotiation is on issues that concerns public authority, the way public authorities can and should access to data, rather than the behavior, the practices, the compliance of private entities, which indeed have not been as such affected by the Schrems II judgment.
Terrific. Again, I know you can't comment on certain things, so I'll ask, but feel free to say you can't. Are you at the point where you're exchanging actual text? Have we gotten to that point in the negotiations, or is it still a principles level discussion?
I'm not going to indeed enter into the modalities or the way these negotiations are carried out. There are frequent and detailed exchanges about solutions. I mean, we are at the stage where I think we have a good understanding. We have reached a good understanding of what the requirements are, the requirements that need to be fulfilled. And now it's the negotiation that talks about how to get there. And then when you discuss how to get there, you become quite concrete in terms of the solution. So really, we are at the stage in which we are exploring those solutions to try to make progress.
Well, I have a lot more questions. Maybe I'll come back to that in a few minutes, but I thought I'd at least talk for a minute, Bruno, as well. There's obviously been now adequacy decisions issued with respect to the UK, an important, again, reconfirmation about frameworks that permit the transfer of data between EU and the UK, which obviously would have been enormously disruptive in the absence of such a finding. Just for, we had a very lively discussion yesterday with folks on the P Club and Bob Litt and Glenn Gerstel, formerly of NSA, on the national security front. So, for folks watching, did the Commission subject the UK to the same level of review and scrutiny with respect to, national security or collection practices that have essentially been applied in the context of a review of US practices for adequacy?
Of course. I think the requirements we have to fulfill and the requirements that have been set by the Court of Justice, which, let's not forget it, is the equivalent of the Supreme Court for the EU, are not US specific requirements. They have been applied to a case that concerned in part an instrument, a transfer mechanism to the US, the privacy shield. But as you can see already in that judgment, the SCC part, the model clause part, this is a judgment that has a much broader scope. And what the court said in Schrems 2 is the checklist, constitute the checklist we have to go through and to fulfill for any adequacy decision. And we did this recently with two adequacy decisions. The one concerning the UK, I can come back to them. We just adopted on Monday, so just before jumping on the plane to come here, we finished that work. And the one also we are proposing with respect to South Korea, where we concluded the negotiations a few months ago, and we have now published our draft decision that needs to go through our decision-making process. I think we published it, if I'm not wrong, last week. And you will see in those, both in the draft Korea decision and in two decisions adopted with respect to the UK, that a very large part of those decisions, the reasoning part, is about assessing the conditions, limitations, safeguards that apply in case public authorities seek to access data under exactly the same requirements we are discussing with the US. By the way, contrary to what I often hear, first shows that those requirements can be met by very different systems. You will agree, I think we will agree that South Korea and the UK are two different systems. And that also, this is not about, shutting down national security agencies. Fighting national security threats is important in the EU, is important for the UK, is important for the US, is important for Korea, for any modern country in the world. But and that we have systems. Think about South Korea, the type of threats they are facing, or rather develop national security systems such as the UK one, which we believe meet those conditions. If you look at the UK decision, you find a number of elements that are interesting in terms of a strong reliance on the principle of proportionality and national security, in terms of pre-authorization by a judicial body of surveillance measures, and in terms of access to a redress mechanism, a specific tribunal in the UK dealing with individuals' claims on surveillance and their compliance with human rights, including privacy. So indeed, those are criteria that apply across the board. and that of course apply also, first of all, that's also something which is often misunderstood, to our own member states.
So it really it sounds like obviously proportionality, accountability, redress are absolutely sounds like key focuses for you, Bruno, as you're reviewing, you and the commission and the member states review any third-party country for purposes of adequacy. How do you consider and how do you balance the level of collection, the overall democratic scheme of a country when you're looking at these other mechanisms? I'm just going to put a hypothetical. If a country had, quite a non-democratic, autocratic, overall regime, and you have on the books documented accountability, proportionality, and judicial redress that are not necessarily independent, how are you assessing that? And by the way, the reason I'm asking this is until there's a new adequacy finding with respect to the US, a lot of the language in the standard contractual clause guidance that was just issued does put a burden on a company to try to make some determinations on a country by country basis when you're transferring data to a third party country. So it would be helpful, I think, to understand how do you and the commission think about it when you're making that kind of a determination in the context of an adequacy decision. And you have to look at the regime together with what's written on paper about these kinds of concepts.
Well, there are many questions in your question, but let's not forget we're talking about whether you call it privacy or data protection. We are talking about what is for us, and that's the rationale behind all of this is a right, a human right. We call it a fundamental right. And of course, for that right to not only exist, but to be effectively protected and effectively exercised, you need a certain type of legal structure, environment, ecosystem, which can only be the one of course, democratic societies. And I'm very happy that you are asking that question, because that's far from being, of course, only a European question. We see more and more that like-minded countries have identified this challenge of data being a strategic asset, which in certain circumstances can fall in wrong hands. Let's not forget, it's not the EU, but it's Japan that has launched the Data Free Flow with Trust initiative, where trust means essentially trust in the ways a government can access data. Let's not forget, I think it was also last week, a new executive order adopted by this administration in the US, which tries to address a number of the behavior or the risks that are associated with data being transferred or being, in any case, falling under the control of companies that are associated with authoritarian regimes. All of this is now part of, I think, the global conversation with like-minded countries. It's a very good news, because I think that one of the ways we will resolve this beyond the bilateral negotiations, which are of course very important, is to come together as like-minded partners, and recognizing that all our systems are based on a number of common, not only common principles, but common safeguards that are not only translated on the books in law, but that are also subject to oversight, subject to redress. You see a sign of this also in the ongoing work at the OECD. That's the first time that there is work at international level in trying to identify common principles when it comes to access by government to data held by private companies. I think that's a work that we are very much supporting ourselves as the EU and all our member countries. And where you have OECD members, and I think it's the right club, because we're talking about democracies, we're talking about like-minded partners. Maybe the OECD was not the natural candidate deal with these issues, but I think it's a great opportunity, and that shows the importance of the challenge and the importance of coming with an answer, with a common answer as like-minded partners.
Yeah, I mean, it must be an interesting and difficult job at actually going in to negotiate adequacy, because the level of complexity can be high, Bruno, with a fair amount of judgment. I think it's helpful for our community to hear that the same principles apply, and especially when you're going to do it with other countries. From the United States perspective, I can say for a lot of companies that are trying to do the right thing right now, it's been I don't think anybody's seeking sympathy, but the moving set of standards and the issuance of additional guidance under, for example, on SCCs, it does pose a challenge if you're trying to do things within your control the right way, and there are things outside of your control that are difficult to monitor and to assess. It puts a very difficult challenge on companies to make a determination of how you do a data transfer appropriately. And we do hear that certain regulators in Europe are calling for detailed documentation of assessments of countries under those kinds of frameworks that are just difficult to do, I think. Do you have a reaction to that?
Yeah, but first, we don't we don't want to underestimate or minimize those complexities, and that's one of the reasons why we are working so hard and intensively on this negotiation with our US interlocutors. But that's not the only thing we have done in the past months. We have, I think, and that has been welcomed by stakeholders, including by the business community, modernized significantly the standard contractual clauses, including on those aspects where we have tried. We cannot substitute, of course, ourselves to the assessment that companies need to do, but where we have provided companies with a checklist of criteria, factors, parameters that need to be taken into account when carrying out that assessment of their transfers. We have also worked, and that was significantly commented, worked very hard and very closely with the EDPB to make sure that the recommendations they issued was convergent with the approach we adopted in our STCs, in particular on questions around government access. Therefore, I think that has helped. I'm not saying that it's it's sort of the magic solution that makes everything easy, but that compared to a few months ago, a company that needs to indeed carry out that assessment has a number of useful tools. There too, it's interesting to see that we are not alone. Model clauses, because they present a number of benefits, including the sort of off-the-shelf nature, are increasingly used by other systems. We have seen STCs being recently adopted in New Zealand, for instance, STCs or model clauses being adopted by ASEAN, the Association of South Asian countries. And this issue of governance access, we understand its difficulty, its complexity. Of course, companies are neither legislature or governments, but this question of government access will not go away, because it is, and not only because of Trends 2, but for the reasons I've briefly mentioned before. It is a decisive issue, and an issue which is seen increasingly as a distinctive feature between democracy like-minded countries and other regimes in the world. And it needs to be factored in an assessment of transfer. We are trying to our, if you want, unilateral instruments such as SCCs, but also to our bilateral or multilateral work such as the OECD, to try to develop a common understanding of these issues, common standards, common principles, so that companies will be able to rely on them when looking at a certain transfer at a certain country. As you've seen also in our SCCs, we have tried to stick as much as possible to what is our understanding of the court's ruling in Schrems 2, which is an understanding, that this is not a binary issue, that you can have transfers to a certain country, which in light of a number of factors, such as the nature of the data, such even with a number of caveats and conditions, the experience of the importer in that system, the answer to the question and to the outcome of the assessment of the risk associated to the transfer may vary. I think that's an important element which needs to be taken up into account, and which has also been endorsed by the EDPB in its recommendations.
Yeah, Bruno, I mean, that was a very, very important bit of guidance. The fact that it's not binary obviously then leaves some ability to look at the facts of a particular company and the area and actually move an SEC forward. And I really commend a reasonable approach by both the EDPB and obviously with heavy advice from a lot of stakeholders, including your office, in trying to issue something to help the community.
We will, if I may, the court very much insisted on the circumstances of the transfer, and we need to take that word circumstances seriously. And indeed, there are a number of facts, of factors, of variables that may distinguish one transfer from the other. Let me also say that our work on the SEC has not ended. We want now to develop user-friendly Q&As to address a number of practical questions which will emerge very soon from the application and the use of the STCs. This will be something that will be done not by me or my colleague close in our offices or in a house actually in Brussels, but we will do in a very close consultation with stakeholders. Therefore, we also ask feedback because I guess the work on the STCs, on the negotiation of the new contract has started. Where there are questions, what are the main issues, and we will collect those questions, try to answer to them, also in a dynamic way. This is not going to be a document that will be adopted once forever, but that will be an online tool that will be regularly updated. This is also, I think, one of the things we will do to try to clarify a situation that we understand is complex, and believe me, we don't underestimate that.
Well, look, Bruno, I know you had a time limit for us today. At some point, I think it would be helpful to have maybe some additional dialogue with somebody in your office or others at EDPB on the SECs, which are very, in some ways complex, and not, if you haven't spent a lot of time in this particular area, certainly on the US side, and you're at a company interpreting them, the community is quite hungry for discussion on that subject, and maybe we could go a bit deeper with some of your colleagues at some point on that.
Absolutely. Let's also not forget that we have received more than 200 submissions in response to the consultation we did on our draft. I think you've seen that there have been a lot of changes that reflect what we have heard, but we also understand that now we have entered in another phase, which is the one of the implementation, where many companies have to use these SECs, have to negotiate or renegotiate certain contracts, and indeed very much looking forward to a detailed discussion and a detailed feedback. As I said, this is one of the things we want to do in the coming months in terms of developing a very practical sort of guide to the use of the SCCs.
Well, look, Bruno, again, I want to be respectful of your time. So from our side, first of all, thank you for taking the time to speak with us. You're in the midst, I suspect, of a very important set of dialogues that affect a lot of different frameworks. The Privacy Shield or an adequacy decision with respect to the US has a new one on whatever it's called, Privacy Shield 2 or anything else, obviously will have an enormously beneficial effect for all of those companies, certainly small and medium-sized companies that have committed and are doing a lot, to still comply with the Privacy Shield, even if they don't get the benefit of a means of transfer. It materially affects the certainty and usability of standard contractual clauses and binding corporate rules. And then, of course, we have in California, Bruno, now the first real comprehensive state privacy law that has a lot of, one would say, essential equivalencies with GDPR, and the potential for at least a state or maybe multiple states at some point, hopefully, to be deemed adequate would be a very significant, helpful moment in terms of convergence of enabling transfers. But I think a lot of this is all going to come down to reaching a new deal and a new adequacy decision here. So can everybody leave this conversation with some sense of optimism, perhaps, that we may reach a deal at some point here soon, Bruno?
Well, I think there's I'm certainly, if I compare the nature of the transatlantic conversation of privacy to where it was only a few years ago, that makes me certainly very optimistic. I think it has become a much less ideologic conversation. I think we all agree on both sides of the Atlantic on the need to have a credible, serious privacy rules in place. I think that in the US, you are now facing, and therefore I hope one day addressing the same challenge that led to the adoption of a privacy law at European level, which is the risk of fragmentation. We were there 10 years ago. I mean, one of the main reasons for the adoption of the GDPR was that there were too much fragmentation and too many divergences, and therefore compliance costs amongst our, at the time, 28 member states' privacy rules. We are, of course, very interested and observing with a lot of interest what happens at state level. Whether this will mean to lead to adequacy or not, I think we see that those rules are developed, reflecting, of course, some choices that are specific to the legislatures that adopt those rules, but those laws tend to be based on convergent principles, on converging rules, and also converging governance mechanisms. If we see also what is happening in California, I think that this should also lead to more cooperation on the ground between our enforcers and the new enforcers that either already exist, like in California, or will be created in other states. That can help a lot, because I think that if we want to have more legal certainty, we need to work more on cooperation in terms of not only on enforcement, but also on developing, if not common guidance, at least a common understanding of some key or basic privacy principles. All of this can help a lot. I was very happy to see that there have been already a first dialogue between the new Californian enforcer and the European Data Protection Board. This is something we really want to encourage.
No, I can imagine, and for a lot of reasons, that level of open dialogue, I think, will help in a lot of ways. Well, Bruno, thank you very much for joining us. I know you just landed and you're about to go in and out of meetings. we're a lot of the community is rooting for another framework and another adequacy decision. So best of luck for both sides in reaching it. And thank you for taking time with us. Then the next one of our spokes is going to be in person. So we hope you'll actually be able to join us in person at one of them soon.
Thank you. Thank you to you, Justin. Thank you to your audience. And see you soon here on Europe. Bye-bye.
Bye-bye. And with that, this is our last panel, our closing keynote with Bruno today. For everybody, I'll make it brief because we're at the end of two long days. I just want to say on behalf of our whole team, first of all, thank you to the entire Wirewheel team, all of our speakers, our panelists, our partners who contributed their time to make this just a phenomenal event. I also want to say just two things at the end of a long 18 months together, making it through COVID. The first is thank you. Thank you to our customers and our partners and for all of you sticking with us and for contributing so deeply to the community and in your time. And so in addition to thank you, I'll say we missed all of you. We're really looking forward to seeing everybody in person at some of these events or back in the community soon. And with that, our Spokes Global Conference 2021 is closed. We'll see you all soon.